2023, docket V. All right, we're on for fact-finding or trial today involving Mr. Barron's petition from October 27, 2023, docket V 57-17-23B. Sir, are you ready?
Yes.
Ms. Whalen, are you ready?
Yes.
Ms. Obolinski?
Yes, Your Honor.
All right, Mr. Barron, what's your first piece of evidence?
The certificate that basically I did attend this is the program that you wanted me to enter with ACR, I believe, for the chemical dependency program and completion, and also statements from that program that says that basically I did in fact speak with this counselor about Damon Barron, because you told me that that was the reason why you was not letting me have my supervised visit the last time, because you didn't know.
So you want to introduce those documents in some way, shape, or form to the court to show satisfaction with the prior order? Is that right?
Yes.
Okay. Have you shown them to anybody else
Oh,
here?
ARS, basically that's what ARS. I sent it to your office.
I don't get paperwork directly from people. I can't get something from you or from Ms. Whalen.
Okay.
No one from the court here. You may send it to the office. Do you want us to make copies of it?
Well, I have copies.
Can you show them to the other parties involved in this case?
Yeah.
That's your own. All right, so, Mr. Barron, you've handed out copies of what you want to have introduced as evidence, correct?
Yes.
All right. Ms. Whalen, have you received a copy of the things that he's handed out?
Yes.
Ms. Obolinski?
I received copies, yes, Your Honor.
Sorry, hang on, I couldn't hear you with the copy.
I received copies, yes.
Okay. So, Mr. Barron, how do you want to get those in evidence? What's your plan here?
Well, basically, I handed them, I'm not sure what you mean.
Well, as far as evidence is concerned, there's a couple different ways in which you can introduce evidence. Specifically, in most common ways in family court are through testimony of yourself or of another person, or there's sometimes there are documents that can be introduced, such as you're trying now, and you put them in through the people who are in charge of making those documents, or in some other way, shape, or form that's appropriate. And I know we've gone through this before, and I know it's difficult to do so as a pro se person. So, unless it's done on consent, I'm not sure how you want to get those introduced.
But I do have copies, so definitely, I guess like how you said, we're gonna do it as of right now with verbal consent.
All right, you're asking for it to be done, all right. So is either of you, with regards to the fact that he wants to introduce these documents, consent to them coming in?
No, Your Honor. No, Your Honor.
Is there another way you can think of?
I could also send copies to the court if the court needs them.
Well, I'm not allowed to see them until they're actually received in evidence. So if they were received now either on consent or through a proper foundation being laid, I could read them. But until then, I can't. So it comes back to that laying a proper foundation to get the documents received in evidence for me to be able to read them.
And for you to get them, for you to read them, basically. Well, you have these paperwork because you deal with CPS, so you can get a hold of those copies anytime you want.
Your Honor, excuse me, I'm sorry. I don't really hear Mr. Barron too well.
Yeah, he's very soft-spoken.
Yeah, what I was saying was that basically, like, all these copies that I'm sending are, you deal with CPS, so you should be able to get any copies of what it is that I'm handing over to Janine and Damon's counselor.
That doesn't amplify your voice, that just records it.
Okay.
Secondly, I can't. I don't go hunting for evidence. I don't get evidence from yourself.
In one of the statements here, when you started off a case with CPS to come after me for spray painting, so I believe like you do have contact with CPS.
No, that's an incorrect statement. So the bottom line is, only contact I have with any type of evidence is when it's received in the courtroom or on consent. Sure, the Department of Social Services is here a lot, that's their job, but, I don't have the,
Well, other than that, really, the evidence is basically that I did complete the programs.
so that's what I'm getting at. Now you're getting to the point where you wanna testify, is what it sounds like to me.
Yeah,
Okay,
testification,
so
yeah.
here we go, ready? Raise your right hand. You promise to tell me the truth, the whole truth, and nothing but the truth, so help you God.
Yes,
Great. Now this is gonna be your first form of evidence that you're presenting to me. It's testimony, and it's subject to cross-examination. You can stay right there if you want, or you can come up and sit in this chair, whatever you wanna do.
okay, I'll sit there.
Okay, go ahead.
Basically, as ordered by the courts, that upon completion of a program by ARS, I will have my unsupervised visits reinstated and the time basically limit to be expounded, basically to be given more time with my son. And that's basically what these papers are. They're the papers that the courts have been looking for. The ones prior to that were denied because of it was not the ARS program, but this time it is the ARS program, and I wish to put that into evidence so that basically I could have my visits with my son.
Okay, anything else?
No, that is it.
Ms. Whalen, do you wanna ask him any questions about his testimony?
I have a couple questions, Your Honor.
Now's the time.
Did you show a copy of Judge Burns's order from July of 2018 to the evaluator at any time during your treatment or your evaluation?
Yes, I did.
Okay. And have you had drug testing?
Yes, I did.
Do you have proof of that?
Do I have the proof? No, I don't have the ARS has the proof. That's for their records. No, they don't give me that record.
I don't have any other questions, Your Honor.
Thank you. Mr. Walensky?
Nothing, thank you.
Anything else, Mr. Barron?
That's it.
That's it, all right. Well, Mr. Walensky, you wanna be heard?
Is petitioner resting?
Sure sign, he said that's it.
Yes, I'm resting.
Ms. Whalen?
Your Honor, I would like to make a motion to dismiss based on the petitioner's failure to prove the allegations in his petition that he has done all of the things required of him in the 2018 order.
Mr. Walensky?
I join in the motion, Your Honor.
Mr. Barron, you wanna be heard on that request?
Yes, I've done everything that basically it said. It basically, all it said was basically upon successful completion that I should be granted my visitation, and that's exactly what happened. They have the lawyer and Janine have the successful completion of the ARS program. So my visitation should basically be reinstated unsupervised as stated by the courts.
All right, the request is granted. I don't have any proof in front of me, Mr. Barron, of it. I know you've got documents that are floating around, but they're not properly in front of me. And just like I told you, I can't take a look at the evidence.
I sent it to your office. Your office. That's how basically I got the case started. When I applied for the what is it called, for this case, I sent in every completion paper from the ARS to you also with the paper stating making the case come up. That was what I needed basically for me to get this case, and I got into the case. Now, if you did not receive all the, obviously you did receive to start up the case itself right now to bring me into court, which means that you also have those papers that were sent with the paper for this case right here, which is the successful completion of the ARS program.
No, none of that's true. Anything else? I don't have this stuff. You keep saying it over and over.
So how did you get?
I don't get anything. I don't have anything. You keep saying
So
it.
how do you get anything?
Through this process here in court.
Okay, so I have a copy for you then, successful completion of the ARS program.
But like I said, I can't see it unless you lay the proper foundation for it.
and I verbally laid the proper completion, and I'm giving you right now.
If you didn't, Mr. Brown, that's what I'm trying to say this as nicely as I can, you didn't do that.
This
So there's
is
two ways to get
a
it.
copy for you right now.
I can't accept it. I'm not allowed to accept evidence from one side that's not in a proper form. And the proper form would be either I consent with the other two parties, and they've said they don't consent, or you lay the proper foundation, which is asking a certain amount of questions to a certain individual who actually created the record. You don't have anybody here from that person. You don't have anybody here. You can testify yourself that you completed it, and you did so, and I took that part as evidence, but this paper that you're trying to hand me, I can't accept it. As much as I love to see what it
So
says,
are you telling me that you are not, you don't believe I successfully completed the program?
I have your word only, and the way in which we like to have it done in this court is for the proof of the prior.
Okay. And,
That's the question that Ms. Whalen asked you that was very poignant. Did you share the order with whoever it is you went down to? So, and you said yes, which is a good answer.
Kristen Wilder, the person who basically did the program, she said that basically she was sending you an email also to let you know that that I completed the program.
Again, that'd be a great person to witness it, or to subpoena and bring up here if you file another petition in the future. I would love to hear from all these people who you interact with. I can't. I just
This is your program. You're supposed to have that information.
It is not my program. I don't care if the Knicks or the Celtics win. I just want a fair game. I can't help you present your evidence. I can't help Ms. Whalen present hers. I can't do it. So if she asked me to accept some document right now without a proper foundation, I'm not accepting it from her either. And she doesn't get to send me emails, or Ms. Oblinsky doesn't get to send me emails. Nothing comes directly to the judge. It's stopped by the clerks and by my court attorney.
I did bring it to the clerk.
Again, and it's stopped. Stop. Doesn't come in.
So-
Return to sender. Can't accept.
They did not return it to the sender. The clerk took the papers and she said she was sending it off to you.
That's false. Anything else?
So
I'm not
so
gonna sit here and
so
let you
so
continue to do that.
so when I bring my paperwork to the clerk to present it in the case, it doesn't come to you. That's what you're saying.
When you file a petition, no, it does not come to you. It does not. The petition gets filed, comes up here, and we give it out to each other, all one fell swoop. I come in here and I click on my computer, and I picked up today P. And there it is. We've had a first appearance, and that was the first time I saw that petition. It's screened by the clerks and the clerk's
Okay.
attorney.
Well,
If it doesn't make out a case, it does not get to you.
I would like to subpoena Ms. Wilder to come into court
You
basically,
do that on your next
and
petition? Sure.
on my next
absolutely.
petition.
Yes, today's the day for trial. This is the day she's supposed to be here.
Today, I thought today was fact finding, not trial. Fact finding.
It's the same thing. As I've said to you multiple times over the years I've known you. A trial, also known as a fact finding in family court. A disposition in family court is like a sentence in the criminal court. They're the same type of thing. So, again, my suggestion to you is that I have legal advice and qualified economically, someone might be able to help you with regards to the documents that you have and submitted to the court and see them. Same thing for you, Ms. Whalen, I'll say the same exact thing to you. You're not a lawyer either. So if you're gonna try and get evidence in, same rules apply to you. In this particular case, you didn't have to, because the motion was granted. But in the future, if it happens, I'm not gonna look at anything you send me if it's not in proper form either, and it has to be done in this court.
Okay. The last time I was in court and I did the same thing, I sent you the paperwork that you had basically in your email. You was able to look it up in your email. And you found that basically the original paperwork from the other hospital in 2018 that you had in your email, you was able to pull that up. This time you disregard this situation and choose not to do that. The last time when you pulled it up, you said that I did everything right, and the only thing that wasn't right was that basically that you had no proof with you that I spoke with the counselor who I spoke with at that time about Damon in that situation. The
What's the limit on this one?
the court paperwork does not say that I'm supposed to speak with any counselor about about Damon or anything like that. It just says that I'm supposed to have successful completion of the program, that it's a drug program. It's not a program for you to discuss about your family. So me trying to make me do that type of program is a lie. It's false, because the paperwork from the courts did not say that I had to speak with any counselor about the situation with me and my son, only that I was supposed to go there for a drug program and
Have a good day,
successfully
everybody.
complete that.
Have a good day.
Thank you.
Bye.